La di da di da. This one is going to be very rushed, extremely rushed. I'll wait until I see someone in the chat and then I'll get going. I know I don't have any notifications, I don't think, left today. But let's see if so. All right, I've got someone in chat. Right, let's go then. And people can catch up as they join in because I've got to go out again. I've got a soccer match tonight to go and watch. So this is Jose de Castro v. Pam Wagner et al., the Ohio case. I assume you can hear me. In judgment and separately seeks leave to file a second amended complaint. I apologise for those interruptions. One factual background. In March 2022, De Castro, a California resident, self-described videographer, vlogger, and civil rights activist who has been publishing his recordings on media forums such as YouTube, Facebook, Instagram, and the like since approximately 2020, was at the Arlington City Hall with approximately 14 other individuals, waiting hours for a permit to use one of the rooms for a constitutional teaching session. De Castro alleges that shortly before 5 p.m., a city employee announced that the building was closing and would be locked. De Castro alleges that Wagner approached him after the building had closed and began yelling suddenly to cease and desist his disorderly conduct. De Castro was then arrested by I can never get his name right, Jarek, Blankenship, McKnight, and Fouch, and was taken to the booking area where several criminal charges were brought against him. When De Castro posted bond approximately 2 hours after his arrest, his iPhone was not among the possessions that were returned to him. Despite visiting the Arlington Police Department 4 times between late March and early April to request the return of his phone, De Castro alleges that the phone was withheld from him until April 28. De Castro filed a municipal court replevin action, which was dismissed after his phone was returned and no evidence was presented as to any damages. De Castro now alleges that his phone was searched and damaged to the point of being no longer usable. In April 2022, during the pendency of his state court proceedings, De Castro initiated the incident action under 42 U.S.C. 1983, alleging that the defendants violated his First, Fourth, and 14th Amendment rights. He then amended his complaint to include only claims against the city defendants. The county defendants moved to dismiss for failure to state a claim, and the city defendants moved for judgment on the pleadings. On review, the court determined that De Castro failed to state a claim against the county defendants because he omitted them from his amended complaint and gave no indication that he did not intend the omission to function as a voluntary dismissal. As for the city defendants, the court concluded that De Castro could not assert First or Fourth Amendment claims against them because they possessed probable cause to arrest him, nor could he assert a 14th Amendment claim against them because he was able to regain possession of his phone through adequate state proceeding remedies. The court also concluded that De Castro municipality liability claim against the City of Arlington could not succeed because there existed no underlying constitutional violation. These motions for reconsideration, motion to correct, and motion to amend followed. 2. Legal standard. The federal rules of civil procedure do not explicitly authorise motions for reconsideration of judgments. However, under Rule 59E, a party can move to alter or amend judgment for any one of 4 reasons. 1. There was a clear error of law in the judgment. 2. The movement has newly discovered evidence. 3. There has been an intervening change in controlling law. Or 4. The alteration or amendment is needed to prevent manifest injustice. And there's citations. A motion under Rule 59E is not to be used as a mechanism to relitigate a case, citations, which Rule 59E does not exist to provide an unhappy litigant an opportunity to relitigate issues the court has already considered and rejected. Nor should it be used as a means to raise new legal arguments that could have been raised prior to the entry of judgment. And there's citation. Rather, a Rule 59E motion is an extraordinary remedy that should be granted sparingly because of the interests in finality and conservation of scarce judicial resources. Citation. District courts are to use their informed discretion when decided a Rule 59E motion. Citation. Analysis. Beginning with the first motion for reconsideration, De Castro asserts that the court made an error of law because plaintiff alleges a lack of probable cause and defendants allege the opposite. He proceeds to challenge the court's analysis but relies on facts already in the record and otherwise simply regurgitates arguments previously prevented. Citation. Cleaned up. De Castro notably fails to identify any actual error, legal or factual, in the court's order. And because De Castro's proper recourse is an appeal to the United States Court of Appeals for the Sixth Circuit, this court need not and will not entertain arguments that it has already considered and rejected, nor will it entertain new arguments that De Castro has not previously raised. Hi, Unclean Hands. Sorry if I've not said hi to anyone else. I am in a rush. Hi, Randy, Nicole, I see you. As for the county defendants, De Castro similarly fails to show how the court made any error warranting reconsideration. Contrary to his assertion, De Castro did indeed repeatedly fail to address the omission of claims against the county defendants from its amended complaint. Not once did De Castro broach the subject, despite the fact that the county defendants raised it in their motion to dismiss, their reply to De Castro's motion to dismiss, and their response in opposition to De Castro's motion for a protective order. De Castro even failed to acknowledge the issue after the magistrate judge explicitly noted the county defendant's motion to dismiss is based upon the premise that plaintiff's amended complaint eliminates nearly all references to the allegations and claims originally included by plaintiff against those defendants, but for a brief reference to Major Chapman. Plaintiff's response in opposition purports to be responsive to the motion to dismiss, but does not directly contest the county defendant's argument that his amended complaint implicitly dismisses them. De Castro also contends that the court erred when it did not sua sponte allow him to amend his complaint for a second time. He is incorrect. Even the unpublished 6th District case upon which De Castro rests his argument clearly provides that a district court does not abuse its discretion in failing to grant a party leave to amend where such leave is not sought. And there's a citation. And because De Castro points to nothing that makes this matter so uniquely appropriate that an abuse of discretion would arise from not allowing him to amend his complaint a second time, the court finds this argument to be wholly without merit. I'm just reading that, see if there's anything about a clock. I can't see anything about that. Finally, De Castro contends that the judgment contains a clerical mistake because it notes in part that this action came to trial or hearing before the court. As this matter was decided on the motions and the court did not conduct a formal hearing, the court recognises the imprecise nature of the judgment wording and will therefore grant the motion to correct. In my title, I did say that he did get a little win, and that is his little win. Because for the following reasons, De Castro's motion for reconsideration are denied. The motion for leave to amend, the motion for leave to file the second amended complaint is denied as moot. The motion to correct judgment is granted. The clerk is directed to enter a corrected judgment pursuant to this order. So, that was his. I didn't see clock anywhere. I haven't read. That's another message from my son, which I've got to get to when I finish this. There's no mention of clocks at all, which is a bit of a shame, but hey ho. And this is what he got. He got the decision of the court. This is now the new judgment. This action was decided by the court without a trial or hearing. I think an X was in the decision by the court the other time. So Chile has managed to move that X from there to there. That's his win. He's got to go to appeal if he wants to do anything with this. The district court's had enough. as I say, I've got to go out. I've got to go and watch a soccer match. I've got to go and meet my son, who has texted me 3 times already. I'll catch you later. And that's the 4th time he's texted me. Thanks for watching. See you all